Well, hello friends, and welcome to another WSIB Truth Matters, where I separate the truth from bullshit, facts from fiction, in plain English. And today I'm going to talk about a viewer-selected topic. So it's an interesting one, and so let's get at it. All right, friends. So today I'm going to talk about a viewer-selected topic for the first time in 2025. That's something that I'm going to be doing ongoing now for the rest of the year. So if you have a particular topic that you would like me to cover, spanning the legislation from pre-1990 claims up to date, I can talk about a wide range of topics affecting those legislations. So I welcome you to just basically email me the topic you would like me to talk about. And I'll endeavor to do that, although there may be a few, so I'm going to have to be selective. But I'm going to try to get to everyone with that. So this topic today, and before I actually go on here, I'd like to give you a salute to the new year. I hope that you had a nice Christmas with your loved ones, and I wish all the best for you in the new year. Lots of blessings, lots of good health, prosperity, happiness, love, and joy. And the guy knows the guy upstairs knows that I count on him a lot for these things. So from my family to yours, Happy New Year. This is a topic that comes up regularly over the course of the last few years. I did touch upon it a little bit in one of my prior videos, and it deals with the Final LOE review, or otherwise referred to as the 72-month lock-in review. This applies to individuals who've had a claim for either an industrial illness or injury from January 1st, 1998 to present. So the WSIB, according to law, is required to conduct a 72-month lock-in review, so the Final LOE review. Once your claim is set up, that review is done once a year. Some of you may have experienced that. Others may be just getting into it. If you have a relatively new claim. But yes, so under the law, loss of earnings benefits are calculated or reviewed once a year up until the 72-month lock-in, or that Final LOE review. By law, the WSIB and case managers specifically are required on the 67th month to conduct inquiries so that they're preparing themselves and preparing you for that final review. And I can tell you that I have found in numerous occasions, and when I speak about numerous, I'm talking hundreds, if not more, where they're not doing that. And so when they get closer to that 72-month, they know the clock is ticking, and they try to do everything they can to ram it all down your throats to make sure they get that review done on the 72nd month, right? It's part of the bullshit that these people do, right? There's no consistency from my experience dealing with thousands of cases. There's zero consistency. And it seems like the person making the decision is the flavor of the day, whatever the fuck they think that they need to do. But the law requires that they start on the 67th month, so that on the 72nd month, they give you a decision. And that decision is going to tell you what you're entitled to receive in terms of loss of earnings benefits until you turn 65. Whether you're going to receive a partial loss of earnings benefit because they looked in their crystal ball and they deemed that you were going to be able to do something whatever they come up with. You've heard me talk about that. A little bit of cynicism here, but that's just because that's the way I see it. But I am going to cover this a little bit more. Nonetheless, the intent of the law is that if you continue to experience a wage loss beyond that 72nd month, and the board hasn't decided that you have miraculously recovered and are able to become a rocket scientist, again, a little bit of cynicism, that review is supposed to tell you what you're going to get until you're age 65. And it was done. Legislators did this in a way so that the WSIB has a way to examine things over the course of 7 years, which is more than appropriate as far as I'm concerned, much more than generous, where they can review everything yearly, so that you have some stability going towards your 65th year, and you don't have this kind of bullshit uprooting your life all the time, this uncertainty. So that 72nd month, or that final LOE review, it is crucial that it is done on time, on that exact date, and that you are provided with the decision in writing as to what you're going to receive and why, if there's been any changes to your LOE, whether it went down or up, which generally doesn't happen, it goes down. They're responsible to tell you why, so that you can then determine whether or not you want to appeal that decision. That's the way it's supposed to work. The WSIB can defer that final review. Again, I covered this in other videos. They can defer it under two circumstances. One of them is if you are involved in a return to work plan that hasn't been completed at the 72-month review or the final LOE review date, or if you're involved in a medical rehabilitation program that they're paying for, that they're covering the treatment, that they're saying that you require more treatment, because they apply the law loosely when it comes to that as well. Those are the only two circumstances under which they can defer that 72-month review. Otherwise, they have to look at all of the circumstances available on that date, and they have to make a decision, and that decision cannot be disputed by them at any point thereafter. Under other circumstances, and I'm going to cover those as well, it deals with the material change policy, and I'll get into that as well. But that's basically the way the law works. That's the way that legislators intended it to work, to give injured workers some stability, which the WSIB has zero commitment to providing, in my experience. One thing that is very closely tied to that final LOE review and can have a significant impact on that is the choosing of a suitable occupation, SO. You've probably heard this term. And this is where, in many cases, the WSIB will look into the crystal ball and dictate to you what it is you should be doing after your injury if you're not able to go back to your pre-injury employer. And believe me, there's a lot of looking into that crystal ball, and I'm sure you've heard me refer to it in the past. This is where they get to deem. They get to deem that you are capable of doing this, that, or the other thing, and you're able to earn this, that, or that much, even though you're not. And then they slice your benefits on that. So because they are very closely aligned, I wanted to touch on this today because I think it's very important. Because rather than allow the WSIB to use their crystal ball and dictate to you what you might be able to do, you need to be in control so that in the event that these things happen, you are able to address them and object promptly. So, some of the things that are important, that are within your control when you're coming to the agreement of what that suitable occupation is, And the WSIB should actually make that determination based on your input. It should be your selection. They shouldn't be making a decision for you unless you're being totally uncooperative. And the WSIB, the Workplace Safety and Insurance Appeals Tribunal, has touched upon this as well. But some of the things that you need to be aware of that are within your control. First, it's that whatever is being proposed as a new career for you, because you're not able to go back to your pre-injury job, is physically suitable. And what I mean by that it's physically suitable and within your restrictions. Now, the WSIB has this habit of telling you that pre-existing conditions, in other words, something that you were suffering from before your injury, or coexisting conditions or concurrent conditions, something that comes up while you're dealing with your injury and you have another health challenge or disability that occurs, that basically they are only required to contemplate or to consider your pre-injury or your injury restrictions or your compensable restrictions. And that's total bullshit and hogwash. And it's a lie, okay? Because the WSIB is required to consider both occupational or compensable restrictions as well as non-compensable restrictions. And the tribunal has dealt with this in several decisions. I'm going to touch upon a couple of them for you so that you can see how the tribunal has taken out their big bat, the big, nice, huge bat, and beat the crap out of the WSIB when they're trying to do something that's unlawful, and that isn't fair. They should consider also the availability of work in your community in that suitable occupation. Because if you're going to go to college or university or get some kind of a retraining program to become an architect, and there really isn't a whole lot of building in your community, and there isn't a big need for architects, well, it may be physically suitable, but it's not suitable in the sense that it's appropriate as far as a suitable occupation, because you're not going to have a job. Your possibility of getting a job is very limited. And so within the law, the WSIB is required to support you in the retraining program or to support a suitable occupation that will get you as close as possible to your escalated pre-accident earnings. That's another criteria. Meaning, if you were earning $35 an hour when you had your injury, and nothing in your community or no suitable occupation is going to allow you to approximate those earnings, then there's a problem. And if they're trying to force you into something that's not going to enable you to do that, then it's appealable and you can push back. And this is why I'm going through these various factors, because every one of them will allow you to push back on their bullshit practice, which has been to shove you into what they think is good for you, as opposed to you going into something that is appropriate for you, for your situation, for your circumstances, for your injury, for your earnings, all of those things. Now, when you're looking at retraining, when you're looking at a suitable occupation that requires retraining and that academically you would succeed in a college or university program, whether it be short-term or long-term, to help you get into a job that's physically suitable, to get into a job that is available within your community, and that will come as close as possible or exceed your escalated pre-accident earnings, then it's important that if you're going to go in that direction, that you should have the academic background that's going to help you to succeed. And in some cases, they will pay for upgrading so that you can then have the skills required and the academic background to enter into a particular college or university program. It's done. It's doable. People do it all the time. But here's the thing that you need to think about, right? You need to think about making sure that whatever program or college or university you're going to be pushed into, that there is a reasonable chance you're going to find employment after that. So it's a program that is recognized by employers in your community and other communities in Ontario, and you have that information available on the Services Canada website in terms of different types of jobs and where the job prospects are in different communities, and there are percentages and earnings and all that. All of that information is provided on the Service Canada website, because that's what they use as well. But they'd rather put you into a one-year program with a college that it doesn't necessarily have a good placement statistic for their graduates, as opposed to spending more money to put you into an accredited college that actually has good placement statistics, where the graduates have a really good, better than 75% chance of getting a job. That's the last one, my friends. And they will try to minimize that, in my experience. I've seen it happen thousands of times, where they will try to save a dollar to screw you over in the long run. And then you're beating the doors down, wearing the soles off of your shoes to get a job. And it doesn't happen. Because not only are you competing with people who are experienced in that career, or individuals who got their training from an accredited college or university, where employers actually recognize it and they look at it and say, yeah, we'll give this person a chance. Or at least give you an opportunity to compete with somebody who already isn't ahead of you in terms of their lack of physical restrictions, lack of experience. And that's always the big one, is experience. Employers like to hire people with experience. So all of these things, it's important that you make sure that all of the I's are dotted and the T's are crossed, so that when you are participating in the SO and determining that suitable occupation, and that you appeal anything immediately and you push back on anything that you think isn't done in your best interest, and you'll lodge your appeal before even 30 days, which is the amount of time you have to appeal anything to do with return to work. And you lodge that appeal, because if you happen to go to the tribunal because you have to appeal something that these idiots decided they're going to ram down your throat, the tribunal will look at that very, very carefully, and they will look at whether or not you got screwed over and pushed into something that you had no hope in hell in succeeding at. And now getting into a particular tribunal decision that I believe really speaks to how the tribunal looks at how the WSIB tries to shove people into jobs that they're not equipped for, that it's not suitable within their restrictions. I'm going to bring up a decision, and I'm going to read it out to you so that I can talk a little bit about it. But this one is a WSIB decision, number 116/23, dated April 28, 2023. So it's a relatively new decision. And in that decision, the tribunal noted that a non-compensable condition is considered when assessing whether a suitable occupation is appropriate for an LMR plan, or, in other words, this applied to cases before January 1st, 1998, but nonetheless, it applies to a return to work plan. And it's laid out in document policy number 190303, determining a suitable occupation. And it states that when determining a suitable occupation, the board can take into account any pre-existing non-work-related conditions, as well as any other human rights-related accommodation requirements. And I want to touch on that one as well. As stated in decision number 83813 in the WSIB, and oftentimes will refer to other decisions made by other panels or vice chairs in rendering their decision. And they call this case law. This provision means that an LMR or a work return plan must accommodate both compensable and non-compensable conditions. This analysis has a very practical underpinning. A worker cannot complete an LMR plan that does not accommodate their non-compensable conditions. Or, as the vice chair puts it in decision 83813, the worker must be able to carry out the plan. So you can't carry out the plan if you have pre-existing or other conditions that are not work-related that prevent you from carrying out that plan, because the WSIB is only considering the restrictions from that plan. And so in talking about, a lot of people sometimes aren't really familiar with the Human Rights Code. And so it's important that I also highlight that for you, so that when you're in this situation, you will know how the code applies to you and how it will empower you to push back to the WSIB when they're trying to force you into something that you shouldn't be doing. And so the Human Rights Code states, RSO 1990, H19, Section 5, Subsection 1, dealing employment. So 5.1 states, every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. So this one drives home to a lot of individuals who have injuries in the workplace or illnesses that produce significant limitations in the return to work, and that in addition to those limitations, they may have another disability that the WSIB neglects to accept. And so the Human Rights Code supersedes the Workplace Safety and Insurance Act. The Human Rights Code applies to every citizen, and it supersedes the Act. And the WSIB has to defer. As the Workplace Safety and Insurance Appeals Tribunal quite appropriately noted, that, well, other conditions have to be accepted so that the worker is able to participate in a plan, because you cannot participate in a plan that you have other conditions that they're not accepting. I'd like to also reference another tribunal decision that really drives this point home when dealing with a human rights infraction or violation to someone on the basis of a religious belief. And this decision, I'm going to put it up here, it's decision 995/23, so also very recent, dated on May the 4th, 2024. And the tribunal, in their decision, states, we note the worker, due to her religious beliefs, was unable to work in establishments that served alcohol, establishments where there is gambling, such as the sale of lottery tickets, and was prohibited from handling pork items. This eliminated many positions for cashiers, such as in grocery stores, restaurants, lottery kiosks, and gas stations. So they were putting this person or pushing this person into a position where they were going to be in an environment that was against that person's religious beliefs. And the tribunal said, back the fuck up. Not going to happen. Now, I'd also like to talk about another topic, which is whether or not you're competitively employable. So in other words, whether or not at any point, at any one of the annual reviews, including the 72-month review, whether or not, based on your medical restrictions compensable from your injury and or other compensable or other disabilities that you suffer from, whether or not you're considered unemployable. And I know that the WSIB will only consider you to be unemployable, based on my experience, as if you're pretty much laying across a slab in the morgue. I hate to be so descriptive, but they push people to do things that they're just not able to do. And again, that crystal ball. So the WSIB has a very comprehensive, I wouldn't say unique, but very clear unambiguous take on what it was required for a worker to be considered unemployable. So in other words, unable to do any type of work and therefore deserving of a full loss of earnings benefit. And for that, I'm going to bring up a tribunal decision, decision 995/23, also recent, dated March 4th, 2024. Actually, this is the same decision as the person I was speaking of a little bit earlier. And so they talk about the concept of unemployable. And so the tribunal goes on. The concept of competitively unemployable, quotes, in quotations, is not defined or addressed in the Act. That would be the Workplace Safety and Insurance Act or board policy. It arises out of tribunal case law. And so the tribunal has gathered sufficient case law where they've made a number of rulings that deal with the issue of competitively unemployable. And so they talk about the consideration of the cumulative effect of medical, psychosocial, and employment market factors related to the workplace injury that would reasonably impact a worker's ability to obtain and sustain suitable employment. In one respect, the concept widens the prospect of a worker's ability to establish unemployability beyond strict medical grounds, which is what the WSIB accepts or expects. Yet, the concept also requires that the cumulative effect of the factors considered achieve the same result as a finding of total medical disability, that is, a total loss of earnings capacity due to the injury. And so when I was talking about some of those things to look out for when looking at a suitable occupation, this speaks to a lot of those factors that need to be considered above and beyond just the medical part of it. Yet, see, for example, and they reference several other decisions. So decision number 114/06, or decision 215/05, or 2380/05, or 1689/06, or 2237 and 47917. And so they talk a little bit about 47917 in the context of competitively unemployable. And they state, first, while the term competitive unemployability does not occur in the WSIB, or the Workplace Safety and Insurance Act, or in board policy, tribunal decisions have used the phrase to describe situations where the worker is incapable of earning any income in suitable employment. Decisions hold that a review of the post-injury earning capacity of an injured worker should not be limited exclusively to a medical determination. And they also reference in Tribunal Decision 66508, the panel stated that the cumulative effect of medical, social, and employment market factors, in other words, is their job available, must be considered in making employment decisions. And then they reference Tribunal Decision 2246/13, stated that employability and post-injury earnings potential determinations, quote, require consideration of the actual circumstances of the particular work in the real labor market where the worker is seeking work in competition with other workers. In other words, they're not looking into a crystal ball and completely oblivious to what's going on in the person's community and labor market and make decisions without having to regard to any of that. The tribunal has done very well in providing a very clear pathway to individuals who need to present arguments, who fit this criteria, who were bullied into, who were pushed into, or coerced into, or threatened into, or intimidated into getting something that it's ill-equipped for them, because otherwise they're going to be left with nothing. As far as I'm concerned, it's akin to having somebody hold a gun to your head, because you look at it and you go, well, I got to do this regardless of whether I am able to or not, because I got to feed my family and put food on the table, and I got to pay my bills, or do what these fuckers want me to do, because, well, if they don't, I'm going to be cut off. So this leads me to another topic that I'm going to talk about next week, my friends. And I talked a little bit about it a couple of weeks ago. And it deals with the WSIB's new intimidation tactics to threaten, intimidate, and bully injured workers into doing things that they're not able to do. And over the past several months, we have been diligently and very carefully putting into place the necessary steps to ensure that we can fight back against that kind of bullshit. And I mean fight back hard. And so anybody in WSIB Settlements who's a member of my company, WSIB Settlements, the WSIB all the way from Jeffrey Lang down to the case managers are beginning to realize that not a very good strategy to fuck with me and my clients in that way. And so if you want to be a part of that strategy, I invite you to do so. It's called the WSIB 2025 Worker Affirmative Action Strategy. And we're going to fight back, and we're going to fight back real hard. And I'm going to talk about the details of their tactics, what they've been doing, which is outright discriminatory. In fact, as far as I'm concerned, it's criminal. And it's the kind of behavior that you wouldn't expect to see from a government organization. But you know what? Even though somebody has taken the leash off the collar, I have my hands fully gripped on it with my team. And so Jeffrey Lang, and this one is for you, my friend. You guys have tried to take me out for over 30 years, and many, like you, have come and gone over the years, and I'm still standing. And I'm going to keep on standing. And I'm going to make sure that the kind of bullshit that you and your organization are ramming down workers' throats all around this province, well, let's just say it's coming to an end. All right, my friends. So thank you for taking the time to watch this video. As you can see, I do tell it in plain English. I don't mince words. I don't shy away from a fight. I don't get intimidated by nobody. Nobody pulls my strings. And WSIB Settlements and my whole team, nobody pulls our strings. Nobody. No government. No union. No WSIB. No special interest group. Nobody. You are the only one who matters to WSIB Settlements and to me. And 2025, oh yeah, it's going to be a year of battles. And you know what? We will lose some battles. But we will win the fucking war. I promise you. All right, friends, celebrate with your family. And I'll see you back here again in 1 week. And Happy New Year. Take care.